right, so welcome to today's episode of the Lawyer's Diary. Today, our speaker will be Nana Freduah Agyeman Osborn. He is the head of legal or managing partner of Osborn's Legal Unlimited. I have a long-standing relation with Lawyer Osborn, and I can assure you that today's discussion is going to be one of the best discussions that we've had so far. I've worked with Osborn during my elementary years as a lawyer, and I can say with authority that I'm convinced about everything that he does as a lawyer and the kind of in-depth knowledge that he expresses on issues like this. He has so many other things that he does aside being the managing partner of Osborn's Legal Pretendo. So, Lawyer Osborn, you can unmute yourself and welcome to today's episode. Thanks for accepting the invitation to join us.
Thank you very much, Jose. I trust, and then greetings to your listeners or your viewers. I trust that we have a very nice deliberation this evening. I don't know if the volume is cool.
It's fine. It's very fine.
Hello.
What's it?
Sina, please unmute yourself, Osborn. All the other people will plead that you put your voice notes on mute pending this thing. So Osborn, you can unmute yourself again. Hello, Osborn.
Yeah, sorry, Jose, sorry.
Yes, so before we zoom straight into action, today's episode is sponsored by Goal Achievers Company Limited. I've shared Goal Achievers Company Limited on my screen. Goal Achievers Company Limited is into wallpaper, profile biogas installation, 3D, Windows, and epoxy. They are in Kumasi, Accra, be anywhere you call them. They can be reached on 0247 505 235. 0247 505 235. So please contact Goal Achievers Company Limited if you need wallpaper, epoxy, biogas installation, 3D, and Windows blind. All right, so Osborn, let's zoom straight into action. I know that we don't have so much of time because I know you're a busy man, and thank you for accepting the invitation. Generally, what are some of the reasons why people would want to leave marriage, which I know was done purely out of love, purely out of affection, and purely out of bond? What are some of the reasons why people want to leave their marriage relations?
Well, also, I think decisions about love change. I have seen people that are in love, but still they have come to court to divorce. The fact that you started a union or a relationship with somebody does not necessarily mean that you're supposed to stay with the person for the rest of your life. And then I think that it's got to do with the decisions that people have to do pertaining to the long standing of that sort of love relationship, whether we want it to continue because of A, B, C, or D, or we want it to dissolve because of A, B, C, or D. And then it's a human thing, you know. People do change. You see somebody, the person give you a particular position, and then with time, you get to see that the very thing that you held on to, that made you start the whole process in the first place, it gets to a point where it becomes a bit checked. When it happens like that, most often than not, people would want to find ways and means to get out. So I think that in as much as we keep on living, remarrying and all that, yes, people will keep on leaving marriage as well, because it's just what it is. And this is not law, but I foresee that in the coming years, we are likely to have much more divorces, because I think that the men that we have these days, we don't know or understand the women that are coming now. The men want to see their mothers in the women that we are having. And unfortunately, women are becoming too much exposed and too much enlightened. So that friction will continue to be there. I'm just speaking basically from the number of divorce cases that I've had to handle, and then why what I think usually causes it.
Okay.
We just don't know how to handle each other. And then that's lack of knowledge, I think it's going to cost us so much. And the likelihood for us to experience more of these divorces, I think it's going to keep on happening.
Okay, so I know there are, various types of marriage in Ghana. We have the traditional marriage, we have the Western or the Christian, or the ordinance, and then the Mohammedan kind of marriage. Does it depend on the kind of marriage I choose that will decide how divorce will be treated in my case?
So you see, when we were bringing into force our law, the 1992 Constitution, we told the wise that if you want to talk about what constitutes the laws of Ghana, the customs and practices of the people were accepted as part of the laws. And you see, every custom has its own way of going about child naming, marriage, dissolution of marriages, and all those things. So yes, I think that it's got to do with the type of marriage that shows how a particular marriage will be dissolved. But that said, I think under our laws, even although a marriage may have been contracted under custom, we can still come to the courts to dissolve it.
Okay, so in terms of the dissolution of marriage, if I decide that I want to dissolve my marriage, what are the steps that I need to take? What are the practical steps that the dissolution must take?
Okay.
Nana, not you. It's me and my friends. We went somewhere.
Hello?
Osborn, yeah, you can continue.
Yeah, sorry. Hello?
Yes, I can hear you.
Mm-hmm. Yeah, I was saying that. Hello?
Yeah, Osborn, I can hear you.
Yeah, I was saying that depending on the type of marriage that the person contracts, no, most often than not, the type of marriages that we bring to court to dissolve are the ordinance marriages. But that said, even when the person contracts a marriage under custom, you can even bring that, because especially when there are issues of custody, children when there are properties involved and all that, you can bring it all to court, and then it can also be dissolved.
Okay, so now I go to court. What do I need to show to the court before my marriage can be dissolved? What are some of the things that the court would want me to say, or what do I need to prove to court?
Okay, well, most people always confuse the legal system in Ghana to that what they see in the movies in America and other countries. Whenever they think about divorce, all that they are thinking about is, okay, well, so the man can bring a document or the papers and I'll sign, or the woman can bring the papers and I'll sign, and they feel that that's how it happens. That's what happens in Ghana, but it's not like that in Ghana. In Ghana, there is only one reason for divorce, and then I believe that you know, and that it should be that the marriage has broken down beyond reconciliation. What the courts will be looking out for is that the one that says that he doesn't want to continue in the marriage, that want to opt out, it must show to the full satisfaction of the court that indeed every possible thing has been done to have brought the two of you back together, and all those things have failed, and that the marriage has broken down beyond reconciliation. But that said, I was like, there are some factors or there are some grounds that has to be shown for the court to come to the logical conclusion that indeed the marriage has broken down beyond reconciliation. And then one of those things that you have to show to the court, or one of the grounds, is that one is unreasonable behavior. And then the very famous one is adultery, where the other spouse have gone to sleep with another person and all that. We have desertion, and then we have when there is separation between the two of them for over 5 years. The desertion should be like, say, for 2 years, at least 2 years, when there is separation for over 5 years. And then when there are irreconcilable differences between the two, that makes the two of them difficult for them to live together as man and then wife.
Okay, so in terms of, let's take it one after the other. In terms of desertion, what are the tests for desertion? Is it that the man stays with the woman, travels, and the woman doesn't hear from the man for a period of 2 years? Or occasionally the man comes, or aggregate, in terms of aggregates, we cannot say that they've lived together for a period of 2 years.
Okay, you see, normally with desertion, okay, we are looking at two main elements. The first thing is that there must be the physical separation, and then the second thing is that the intention to bring cohabitation to a permanent end. So when we are talking about desertion, it's not like, say, I'm living with my wife and I decide to travel to America for about 2 years, and then because of that, there is desertion. No. But the whole essence of marriage is where a man and a woman decides to come together, cohabit, live together, raise a family, live together as man and wife. Now, when there is an act on the part of each of these ones that leads to the other person getting to the point to say that I want to end that sort of cohabitation, that is what we are looking at desertion. So we are looking at the real intent of either spouse that makes the person get to the point of say, I don't want to continue this particular union or this particular living together with you. So for instance, A is married to B, and then for one reason or the other, maybe because of how B is treating A decides to leave the home. She has intentionally moved out. That's the very first element. There's a physical separation. That's if they were all living in, say, Kumasi, she decided to move out, even if it's in Kumasi, to another place and going to live at that place. And then her intention is, I'm no longer coming back to this particular person. So if we see that intention has been shown, and then the person gets to move out for over 2 years, we can conclude that there's been that sort of desertion, and then that could be a ground for the court to dissolve the union.
So the follow-up question to that is that, I mean, in terms of desertion, what if the man goes and the woman still wants to live with the man and goes to visit the man, even though the man has clearly shown his intention not to come back again, would that still be deemed as desertion?
That would be difficult for you to sell to any court. You see, for instance, if the man leaves the woman and then the woman is still interested in the man, the question is who is going to take it to court for that desertion thing? Because if the woman is still following, that means that the woman cannot come and complain that she has been deserted. I don't know if
can the man say that I've deserted the woman, so I want an out? No,
but the man, he himself is saying that he has deserted the woman
because yes.
Well, that would be interesting, because then I would intentionally move out of the house for about 2 years and then ensure that I don't have any contact. It's like I don't have any contact completely with you, because I believe that once the woman comes around and all that, it will be difficult for the man to say that I have deserted you. So I think most of it that know this, the petitioner that comes to complain that the person has deserted me, and because of that, there should be that sort of dissolve. I've not seen anywhere it is actually the man who has left and go to court and say I have deserted her, so let the marriage be dissolved. I was trying to see how we will look at it.
All right, but I mean,
what do you think?
I don't practically foresee that happening. I don't practically.
Yeah, it's quite interesting, you know.
But I mean, in recent times, many people have also complained that in terms of desertion, they are not always the case that somebody has to move out of the house. You can be in the same house with somebody, and then the person doesn't talk to you for over that long period. Is it the test that one needs to move physically out of the premises? Or because
most often, I mean, and from what we have seen from case law, there has to be that physical separation. But the side where you live with the man or the woman and the person decides not to talk to you and all that, all those things could come under unreasonable behavior, because that's clear cessation of communication. And then if there is no clear reason, for instance, you've been with your wife for over a year or two, there's this divorce case I did in Accra, where the moment the lady got pregnant, for over 3 years, the guy doesn't want to talk to her, doesn't want to have anything to do with her, but they were living under the same roof. So that clearly, I think, would be probably captured under unreasonable behavior, and then that could be a ground to show to the court that indeed that marriage has broken down beyond reconciliation.
So aside the desertion, I mean, the unreasonable behavior is kind of a wide net. What are some of the basic things that goes into the unreasonable behavior? I mean, we've mentioned
adultery is not. Adultery is supposed to be a ground on itself, okay. But unreasonable behavior is quite varied, like you rightly said. Anything that, when the court puts it to test and realizes that this is something that a reasonable person ought not to do to another person. It could be captured as unreasonable behavior. And then once you're able to show, you see, what our listeners need to understand is that when it comes to divorce, there is a job for the petitioner to show. It is not as easy as people normally think it is. In fact, most people always think that, okay, I said I'm married, I said I'm no longer interested, so what's the big deal? But no, now even the law is that you have got to actually mount the box and show to the court why you think that the marriage must end. And so now there is witness statement. So it's like a full trial. And you have got to really show. And with unreasonable behavior, there are so many things. In fact, I think we cannot actually clearly state specifically what would be unreasonable behavior. But I think depending on the particular fact that will be narrated or be presented to a particular judge, we can conclude that this behavior is unreasonable. And because of that, the marriage, like what I said, if you're living with a woman for 3 years and you don't want to have sex with her, you don't want to touch with her, it doesn't actually make sense. So these things, we could conclude that this is unreasonable behavior. And then cruelty, how the person treats you. There is this matter that came before me where the man wants to be sleeping with their, I think, 2-year-old child or something. And I mean, some of the issues when they come, so I'm sure that when it comes before the judge, we look at it, they think holistically, and then they can conclude that this behavior is unreasonable. And then you see, the behavior could be lingering on for years. But if other party, the other, what you call it, the either spouse is okay with it, then we don't have a problem. But the moment the other person says that as a result of this, it is making it difficult for me to continue in this particular union with you. So there's got to be an end to it. And if it doesn't stop and it continues, that could be a ground for the court to consider that indeed this marriage, it cannot rationally be expected to continue.
Okay, so now, I mean, once those grounds have been established, should there be an attempt by any of the family members of either parties to resolve it, or that is separate? You don't really have to show attempt that it's been resolved. You can go straight to court and ask for the divorce to be for the marriage to be dissolved.
Well, most often than not, by the time that matters comes before the judge, especially with divorce cases, probably from those that I have witnessed, by the time it gets to the court, most often than not, it means that the issues have actually escalated. Other than that, ordinarily, it wouldn't get to that far. But that said, I have seen situations where people come to court and come and plead that they still want to take the matter out of court and see how, if they can still try and settle the differences between the spouses. And then, yes, sometimes the court does allow it. So it is not really the case that once goes to court, then all hopes are lost and the marriage must actually end. Yes, there is one that I'm doing recently with one of the lawyers in Accra there. And then the moment we issued the petition, the husband through other lawyers came in and started apologizing. I told the wife that, look, you have kids with this man. If it is something that you think is worth considering, why not? She decided to give it a shot, and then we are still talking it over. If at the end of the day, we feel that we have been able to raise a particular understanding, we can just discontinue against that, discontinue the matter, and then they can still go back into marriage. So it's not like once we go to court, then everything is dead. No.
I understand the role of the lawyers and the judges is to ensure that if there's an opportunity of the couples getting back together, the lawyers and the judges should allow that rather than probably insisting that once the petition has been brought before you, it has to go through full trial. Is that the case?
Yeah, because I hardly have I seen any judge who is even very hasty to go into the dissolution of the marriage. Most of it, I know they advise, at least those that have been before, they would always advise that if it is possible, probably you guys should look at it again, especially where there are cases. But you see, some of the matters when they come before the courts, the issues are quite bad, and then it's such that the only rational thing would be that, Charlie, let these guys go their separate ways. It will be better for the two of them.
But my challenge is that, I mean, if the petitioner is unable to prove that the marriage has gone beyond what he or she can bear, would the court still force them to be together? Remembering that it's not a contract of servitude. I mean,
but you see, the sanctity of marriage is the reason why there are laws. I always say this thing when I was doing the pretendo that marriage is not a spiritual thing, and it is not the church that creates marriage. Marriage is a purely legal thing. And if it's a purely legal thing, that means that the laws protect it. There are times or there are situations that you can go before a judge and the judge will say to your face that your marriage has not broken down beyond reconciliation. You should go ahead and marry. So it's not like as if once you go, you are good to go. It's not the case. And that's the reason why we expect or we think that the judges are supposed to be so intelligent and so smart to be able to rationally listen to your respective matters and then come out with a decision whether indeed. And you see, it is a final, the ultimate test is to show that indeed that marriage has broken down beyond reconciliation. So each judge, after perusing all the case and the evidence, and the judge actually is of the honest view that this marriage is one that has not broken down beyond reconciliation. Since the marriage is a union that is created by law, and since it is a law that brings you together, it is a law's responsibility to ensure that if you have the thing is not done, it keeps you together. But I must also add that I have never seen it yet, that the matter actually went through trial, and at the end of the day, the judge said, this marriage, they should still marry. I've never seen it.
Okay, so recently there was a matter that I was privy to where, I mean, the matter was pending before the court. The man has said categorically clear that he's no longer interested in the marriage. The woman still wants the husband and was pleading that the judge should allow them to go to EDR, and it's possible that probably something can work out. The man still was insistent that it's something that he has concluded is not going to work. So the judge's position was that, I mean, you understand? And so why does the woman understand and probably just leave the man to be and move on? Because I think the judge was more or less thinking of the psychological trauma probably the man is giving to the woman. You understand? So in that case,
the man wanted to stay in the marriage, or the woman wanted to stay in the marriage?
The woman wanted to stay, the man wants to leave. And the woman was even pleading that probably they should try an EDR for things to see whether
the man was a petitioner.
The man is a petitioner.
So you see, also the interesting thing is that it's not even about the man or the woman. That's the reason why there is an independent arbiter, the judge. So that's why the judge would have to now look and say that, okay, well, I've listened to you both. I think that this marriage has broken that beyond reconciliation. But then again, if a person says he doesn't want to live with you, what can you do? So even if the court says that the marriage legally they are not going to terminate it, the judge cannot, excuse my language, force the man to come and live with the woman or come and be the husband to the woman or anything of the sort. So maybe I think we have to look at it again so that, as happened in other jurisdictions, it looks like in America, for instance, the parties have a lot of say as to whether they will live together as man and wife. But in Ghana, the judges have the final what do you call it? They are the final deciders. And then like situations like what you're saying, it could be quite some way. But at the end of the day, it's what the judge thinks. But the question that we have to ask ourselves is, the real question is, even if the judge says that the marriage has not broken down, what happens? Is this something that you can actually enforce? That would be difficult.
Yeah. Okay, so I mean, moving to the next area for discussion, how long should a marriage last before someone can institute a divorce proceedings?
Okay, so you see, ordinarily, you should have stayed together as man and wife for at least 2 years before you can bring an action before the court that because of all these grounds which have been stated, unreasonable behavior, adultery, desertion, separation, and all those things, before you can show to the before you can come to court for divorce. However, there have been situations that the court have allowed people to come and seek permission or leave from the court to issue the petition before the mentioned 2 years. So I think that to answer your question, there is no time limit per se as to when a person can bring an action for divorce. Whether the marriage is a day old or 2 years old or whatever, you can always bring an action, but the procedure will change in that if a person who is not married up to 2 years would want to bring an action before the court to dissolve that union, then the person must first of all show to the court why the court should even allow you to issue the petition in the first place. So we call that you have to go and seek for leave from the court to issue the divorce petition. And that the court would have to look at so many things. The only reason that I have seen so far that will allow the court to grant a permission for the marriage to, for a petition to be filed before 2 years is when they see extreme cruelty being meted out to either of the spouses. So that they feel that your life is at stake. Other than that, I shudder to see how any court would allow you. So ordinarily you have to wait for 2 years, and then after that you can come under either of these grounds which I've said.
So aside the extreme cruel manner, if there are unreasonable behaviors here and there, still it does not constitute enough grounds for the court to grant the search leave. And how do we even apply for that leave?
Yeah, but I'll say cruelty is unreasonable behavior, you know?
Yeah.
So you have got to show something that is so serious and most of the time life-threatening for the court to want to grant permission for you to come before the 2 years to ask permission to go and file. I have done, I think, a couple, them very few. And with all those that I did, the spouse that I was representing's life was actually at stake. And then it was such that we had to quickly rush the court to go and end that thing.
Okay, so viewers, we are speaking to lawyer Nana Freduah Agyeman Osborn. He's the head of legal for Osborn's Legal Unlimited. Today we are discussing divorce and property distribution. So far, he's made us understand that before you can seek for divorce, the marriage has to be 2 years. Or you need to prove to the court why any divorce petition should be even allowed for you to institute it. We've also discussed the grounds for instituting divorce petitions or things that you need to prove to the court before the divorce may be granted, outside adultery, unreasonable behavior, desertion. All right, so Osborn, now zooming straight to the next phase of our discussion. When there are children involved in marriage and the court grants the divorce, what happens to the children? Who takes custody? Who is given visitation rights? What are the things that the court looks into?
Whenever a divorce petition comes before a court, and then there are children involved, there is a lot of caution on the part of the courts to ensure that whatever decision the court will finally reach out with regards to who should have custody, it is the interest of the child that must always stand supreme. And by the interest of the child, we are looking at what will be the best thing for the child. It is not for the mother, it is not for the father. But from precedents, what we've seen is most often than not, when it comes to little children, unless situations where the mother, excuse my language, is mentally retarded or having a mental issue, or is in some very weird lifestyle. Hello, can you see me?
Yeah, I can see you. I can see you.
It's a very weird lifestyle. Most often than not, children between, say, 10 years, under 10 years, their custody is usually given to the mother. But other considerations normally come in. For instance, they are schooling, for instance, or who has actually been with a child for a very long period. For instance, me, if I should take me, for instance, if I am to be, God forbid, dissolving my marriage, there is no way that anybody will want to give custody to me. Why? Because how many times do I even get to be with the children? Do I even get, so the court would reason to say that about 90%, the children are mostly with their mom. So if we are dissolving this, why should we give custody to you? Because you don't even have the time. So the judge, I always say this, I say that the court is very wise. So when the case comes, it's about issue by issue, case by case, based on the particular circumstances. They will look at what is the best interest of this particular child in this particular situation. And then based on that, they will make a decision to either award custody to the mother or the father. But most often too, we always give visitation rights. So it's not like as if once custody is given to one of the parties or the spouses, that party forever is restricted from having any access to that child. No. But then there have been situations also where, because of the attitude of the other party, the court can restrict you from having anything to do with the child or the mother for some particular length of time. Yes. So we cannot say that when it goes to custody, we will give it to the mother or the father. But like I did say, it's always about what is the best interest of the child in this particular situation. And when the court varies all those situations holistically, they normally will come to the conclusion that it should go to either of them. But about 90% of the time, it goes to the woman.
Okay, but and the visitation rights to
yes.
the man.
So like
but
with the visitation rights, sometimes you can
define what constitutes visitation rights, as in the man gets to visit the children during weekdays, take them for weekends, during vacations. Does the court define that or leaves it for
yes. At least those that I have seen, they always define all those things. Like even sometimes even the length of time that you can take the children and take them out. So you can pick the child for like we say Saturday from say 10 a.m. to like say 6 p.m. You bring the child back. But sometimes you're allowed to keep them only on holidays. Sometimes over the weekends. It could be anything, you know. And
when those orders are given, are they perpetual orders, as in, or are they perpetual orders that is permanent, or it can be reviewed from time to time?
No, it can always be reviewed. I did one where I represented a man. Initially, full custody was given to the wife, and then I think that circumstances changed, and the woman needed to leave the country. We had to go to the court to review those orders and allow the man to now have custody. So the man is now having custody of the children. Because when the woman was leaving the country, because she had custody, wanted to give the children to her mother. But we felt that no. So we argued to the court understood, and then they reviewed those custody orders. And then now custody was given to the husband. So anytime the wife also comes, he has access to them.
There's a presumption that when a child is below the age of at least 7, custody belongs to the woman. And then after 7, the man can always go for their kids. I mean, I get that those calls a lot. Is it a case in the Ghanaian law, or these are just conventional things which people presume?
No, they are actually nothing. And I don't know where we got all those things from. And then, you see, I think that this mentality where men feel that I'll take my children, I go for my kids, I think it's absolute nonsense and we must stop it. The children does not belong to the man or the woman. The children belongs to both of you, and then most especially, the children belongs to the state, and the state does everything possible to protect these children. So, I've also heard that where the man feels, okay, when the child is below 7, well, the mom can go, when he is of age, I'll go and take my children. No, you can't do that. When the custody has been given and those orders have not been reviewed, it will stand, even if it's a bad order, until steps have been taken to either set it aside or have same reviewed. You'd understand? Or maybe when the orders were given, the court were quite explicit that when you keep the child for this number of years, after that, then the child could also be given to this person. But other than that, I don't think any man is actually bigger than the laws of Ghana. So I don't see where that thing actually comes from.
Okay. So now back to properties. I know there's a very big issue, which, there are so many diverse opinions on property distribution when there is divorce in marriage. When properties are done in the course of the marriage, how is it shared when there's dissolution of marriage?
At first, even coming to the conclusion that a property is a marital property worthy of being shared, it wasn't so big a deal. But now, what I have seen lately is the parties may know that, yes, this is a property that we both acquired during the pendency of the marriage. But the moment the dissolution comes, one of them would want to mount an action and claim that this should be my sole property. And we have been seeing that lately, and it brings a whole lot of issues. But if I may just sum it up, I'll say any property that is acquired during the pendency of the marriage, there are several authorities to that effect. Any property that is acquired during the pendency of the marriage, it is mostly treated as a marital property. And then if it's a marital property, then the law expects that there must be an equitable share of sale. Equitable share does not necessarily mean that they must be shared equally, but we have seen precedents why that mostly it is shared equally. I got a judgment this morning where it was quite similar. about property. Hello?
Yeah, hello, I can hear you.
And the judge awarded 60-40. 60 for the man because he contributed the money and everything, and then 40 for the woman. But my client just took it like that because I mean it's a huge property, and then her 40% was still suffice, and then it was good. So we just took it like that. So when the property is acquired during the pendency of the marriage, most often than not, the usual conclusion is that it's a marital property, and that it will be shared among the two spouses. What we need to understand is that for it to be a marital property, it does not necessarily mean that both spouses might have contributed the money in equal terms. No. Once it is assumed or it is seen that it was actually during the marriage period that the property came into the hands of either the man or the woman, then the two of them would have an interest in the property, and then they have to just split it. Marital property, I must add, does not include gifts that either of the spouses gets during the pendency of the marriage. So I'm married to my wife, and then during the marriage period, her father gives her a gift, like say a house or a car or something. We cannot say that that is a marital property and that we have to split that into two. No.
But what if the property was started before the marriage, but in the course of the marriage, some additions were done onto it? Would that be deemed as a marital property, especially when, say, I have a plot of land before marriage. When we got married, then we built the property together. Or I had even started the building, and during the pendency of the marriage, we fenced it. How will the court treat that such properties?
Normally, that one is a bit difficult, but they always look also at the substantial contribution that has been made by the other party. So there is a matter I'm doing in Takwa now where the man bought the property, yes, even before they got married. But when they started the project, he lost his job. So the woman had to use her money to build everything. We have not concluded for us to know what the judge will say, because our argument is that the woman has made substantial contribution to that particular property and that she should be entitled to have share of the property. So we are waiting to see. But I think also that the one who owns a portion of land by law owns everything on that thing from the ground to the skies. I believe you are aware of that.
Yeah,
so,
yeah,
so it's a bit tricky, but I am yet to see where. What do you think?
Well, personally, I think that the court should look at the contribution that either parties made when they became married. It can't be a total marriage property. I don't think it should be a total marriage property. I think my definition of marital property should be properties that was acquired from the scratch during the pendency of the marriage. And if there is any addition that was done in the course of marriage to an own property, we should look at the contribution that you made. So if that is not the case, then it means that, Osborn, if I've built my house, I've got my property, and one way or the other, every 5 years we paint it, or we do some maintenance in the house. Because we did the maintenance in the house, would that property be deemed as marital property? No, it shouldn't.
I see. You have always said what the mistake that we make as men is we usually set the place up as a matrimonial home. You get what I'm saying? So once we are and then that coupled with the little contribution that she may have made either towards the painting or whatever, it must mean something. And then with the matrimonial home, you know that the moment you are dead, she has an interest in that particular, even if that's the only property that you have.
If you check the chronology of case law, I mean, in terms of its development, at first it was substantial contribution, and then later it came that you don't even have to prove substantial contribution. All that you need to prove is that the property was done in the course of the marriage. And some judges have even said that the fact that the woman is able to give you the peace of mind for you to go outside Tapa, Daman, Tapadi, and be doing your cases while she's washing, and then in the evening also gives you some pleasure for you to relax your body for the next day. That alone to them was deemed that substantial contribution. And that's when the equity is equitable, everything comes into make it quite late.
You see, was last week, or was it on Monday? I was talking to a senior lawyer, and we were discussing something similar to this, and then we're like, marriage is the only situation that something that your wife had no hand in, the court can actually take it and give to her. My simple thing is this: that if you're a man, keep working harder, and then forget about the properties, because
forget about the properties that you make.
I mean, because
I also can see if after all that we are doing, hustling, going up and down, something should happen, and then you are treated as an outcast in your own vineyard. I mean, it's so demeaning and so psychologically wrong that, I mean, a man should work hard, get all his properties, and then, I mean, in the foreign land, you can go empty-handed, especially when there are kids involved. So the woman takes his part, they also take part for the kids, and then you are left with zero or nothing. You understand?
So get more properties. So because you see, now that is the law, and then it will be difficult for you to change. There's no authority which has come and altered the Mensa and all those other cases which hangs around our neck recently. So there's little that we can do.
Okay, so I mean, if you go to the foreign jurisdiction, I know of the prenuptial agreement where parties decide how their property should be shared should the marriage go into the dust in the future. It's quite alien to our judicial system. Is that not the case?
Yes, it is.
Yes. And do you think that in terms of policy-wise, it's something that we should consider?
Trust me, if I begin to tell you what I think, your listeners might take the wrong view of me. So I just leave it there like that. But no, I don't think. I think we should just let it be.
You reserve your opinion, because I can see among the listeners. I mean, I've seen some things. So you reserve your comment.
Yes.
All right. So thank you very much for joining us. The program is The Lawyer's Diary. Every Friday between 6 and 7, we bring you topic which is worth its content. Today we have in our midst lawyer Nana Freduah Agyeman Osborn, who is the head of legal for Osborn's Legal Unlimited. He's taught us so much today, and in fact, he has helped us to revise our notes on divorce, how to even institute divorce actions, what are the things that we need to prove to court in terms of custody and access rights, and then he's also expressed his opinion on property distribution when there is a divorce. So, Lawyer Freduah Agyeman, thank you very much for your time today. I really appreciate it, and it's been one of a very insightful program for me. We'll open the lines for one or two questions. Dennis Amwate said he wanted to ask a question. Nana Dako is joining us from China. Dennis Amwate joins us from Italy, and then some other people. So Dennis Amwate, you can unmute yourself and then ask the question. Hello, Dennis. Okay, so he said, if you're a man, work harder. Thank you, sir. Okay, so he has expressed his opinion on that. So, Lawyer Osborn, thank you very much for today. I really appreciate your time. Alice, and then another, if you have any questions, you can ask Lawyer Osborn so same can be explained to you. All right, Lawyer, thank you very much for your time. What do I get toward this? Okay, so we have a YouTube channel, Lawyer's Diary. You can go to YouTube, subscribe to our page. On Instagram, we are Lawyer's Diary Global, and then on Facebook, The Lawyer's Diary. Watch our videos, subscribe to our pages, like our pages for all upcoming programs. So, Lawyer, I'm very grateful. I'm very grateful. Thank you.
All right, so have a blessed evening, and thanks for having me. I'm most grateful too. All right, bye.